Hello everyone, so welcome back to the Law Learning Capsule, and on this episode we are going to talk about the development of equity and then the fusion of equity and common law. So with the development of equity, it was noted that after the Norman conquest, the rules of common law became accepted as the rules of law in England. So at that time, the common law was very rigid. If you remember, I said in the previous episode, the common law was very rigid and could not cater for all the obvious wrongs or could not cater for all the actions that were brought up by the people of England. So for this deficiency that was in existence with the common law, the rules of equity was developed to curb the harshness and deficiencies of common law. So equity just came in to supplement or to add up to what the common law could not cater for. So if, let's say, you brought, in the previous recording, I made mention of bringing an action with regards to assault and battery, and when you bring an action with regards to assault and battery and there was no writ to support your action, then you do not have a remedy. But with the introduction of common law and with the introduction of equity, it can be said that now they have come to supplement the law in the sense that now when you bring an action, even under assault battery, you find a remedy because equity has come to supplement the law. It has come to add up to the law, not to become the main law. It's just like an addition to the law. So the king began to delegate the functions of petitions that were brought to the chancellor. So at the time, the king was supposed to handle all the major issues by petitions. But when the petitions kept going on bigger and bigger on the king himself had residual judicial power. So he could delegate his power to other people, and then in this instance he delegated the power to the chancellor, and the chancellor at the time was usually a clergyman or a king's confessor. So the chancellor or the chancery evolved as a judicial body that was known as the Court of Chancery. So it emerged because the king had delegated his powers to the chancellor. The chancellor created a court called the Court of Chancery. You understand? So by the end of the 15th century, this judicial power of the chancery was fully recognized, and William the Conqueror formulated and enforced the uniform rules of law for England. So then after he formulated this, he still kept the royal courts. The royal courts, I made mention of it in our previous discussion, our previous recording. The royal courts were still in existence. So then the Court of Chancery basically came to effect to help to solve the issues that the common law was not able to solve. So the rules of equity was different from every chancellor to chancellor. You understand? So it went on and on that now the equity came to supplement the law, and that the royal courts consisted of the King's Bench and the Court of Common Pleas and the Exchequer Court. However, the Exchequer Courts were concerned with only taxes and fiscal matters. So when it has to do with these matters, the king, in order to ensure the application of a unified system, he would discharge judges to go and hear and determine cases of this matter. So the judges normally apply similar solutions to similar problems. That's basically like a stare decisis. And then the theory of judicial precedence evolved. You understand? So then they were deciding most of the cases based on previously decided cases. So with this brief, it can be noted that common law was defective, and the rules of equity came to supplement the common law because it was very rigid and it was very rigorous. So there was this case called Dudley versus Dudley, where it's established in this case that equity qualifies, moderates, and reforms the rigors, hardness, and edge of the law. So then the office of equity is to come and support and protect the common law from shifts and crafts. So it just came to add up to what the common law has already built. And equity therefore did not come to destroy the law, but it came to assist the law. So that is from this that we have various maxims of equity, like he who comes to equity must come with clean hands. Equity will not suffer a wrong to be without a remedy. He who comes to equity must come. Okay, I've already made mention of this. He who seeks equity must do equity. Delay defeats equity. Equity looks at the intent rather than the form. Equity aids only the vigilant. Equity imputes an intention to fulfill an obligation. Where the equities are equal, the first in time shall prevail. Equity looks on that as done which ought to be done. These are some of the maxims that were enunciated in this case, Dudley versus Dudley. So these maxims were brought up in this case. So in our next session, or in our forthcoming sessions, I will explain each and every one of these equity maxims. But for now, this is the development and the fusion of equity and the common law. So thank you.